Hi, good morning, everyone. It's a great pleasure to welcome you to another event organized by our law firm, VLK Advogados or VLK Advogados. Um, our goal is to straight to the point regarding the most relevant impacts related to international data transfers. We will address this subject primarily in Brazil, also across Latin America, and also in the United States and Europe. So we'll try to cover those four countries or parts of the world. We will focus on practical aspects based on the issues that our clients most frequently brings to us, addressing four main topics like risk assessments and due diligence alignment, contract adaptation, reconciling Brazilian SCCs, standard contractual clauses, with existing clauses, safeguards for sensitive data in the cloud, DPIAs, and Resolution 19 requirements. Resolution 19 is from the Brazilian Data Protection Authority, our DPA. And the fourth matter is due legal basis in Brazil, aligning with EU and US transfer models. And before we begin, I want to extend a special thank you to Mateus and Alexandra. The planning and realization of this webinar are the result of their dedication and vision. So without them, today's event simply would not have happened. Thank you both, Mateus and Alexandra. I also want to thank our guest speakers, Fabio Kalil and Tahik Laksimi, who graciously accepted our invitation to share their knowledge and perspective on such a relevant and sensitive topic, mainly because in Brazil, in 2 months, 3 months, we will have the resolution 19 in Brazil. So this is something that companies in Brazil are really struggling to be compliant with. And your presence, Tahik and Fabio, adds great value to the discussion and reinforce the importance of a technical and responsible dialogue. And for those joining us for the first time, I would like to do a brief introduction of our firm. VLK Advogados, or VLK Advogados, is a boutique law firm focusing on matters such as data protection, cybersecurity, responsible AI, intellectual property, digital litigation, and legal design and visual law. And we have a focus here in our law firm. We try to really focus on legal innovation and real world impact, helping companies to face regulatory challenges with practical and secure solutions. And we have a clear purpose here is to use the law as a driver for innovation. So we really believe that law and innovation, they can walk together, and we truly think that we're addressing that in that webinar. And I would like to ask you, the audience, to feel free to interact via chat. At YouTube, you can ask questions, make comments, so you can make today's session yours. And we are certain that it will be a valuable, insightful experience for you and also for us. And again, thank you, Mateus, Alexandra, Fabio, and Tahik. And let's begin without more delay. Mateus, you have the floor. Thank you all.
Thank you very much, Caio. Good morning, everyone, and welcome. It's a big pleasure for me to be here today, and especially to introduce our first special guest, which is Tahik Laksimi. He's a professor from whom I've had the honor of being a student during my time in the University of Lyon. And so Tahik is, as I said, he's a professor. He teaches private law and criminal science at the University Lumière Lyon 2 in France. He's a lecturer as well in postgraduate program in law and artificial intelligence in the Autonoma Academy in Portugal. And he's also head of research department at the French National School for the Judiciary. Besides that, he also plays a key role in shaping the future of justice systems in Europe as a member of the scientific committee of Just Fair EU, working group on artificial intelligence in justice systems. and he serves as an expert consultant to the French Court of Cassation. So beyond his academic approach, he is also a practicing lawyer, so he will bring us a bit of the practical view of the European framework. He is registered in the Paris Bar, and he regularly advises both public institutions and private companies. Today, Professor Laksimi will bring both his academic and his practical background to share with us some insights on some of the most pressing issues around the international data transfers under the GDPR, the evolution of the standard contractual clauses, the SCCs, within this European framework, and the role of the national authorities in Europe, especially in France, and some of the most important issues that the companies who share data across jurisdictions may have in their practical day-to-day basis. So please join me in welcoming Professor Laksimi. The floor is yours.
Thank you very much, Mateus. Thank you very much for the organizer to let me the opportunity to share with you some knowledge and to have this discussion about this important topic about the SSCs, which is a topic, as you know, in the intersection of data privacy and international commerce. So it is something that every company should pay attention. They have an activity around transferring data across. I will examine in the time I have with you three fundamental aspects. It's a choice, an arbitral choice to be able to just emphasize in what appeared to me something interesting about SCCs and letting the discussion after take place. Very quickly, first, I will talk about the SCCs. What are SCCs with some basic terms? I will quickly, secondly, talk about the requirement they must meet, and it's probably here we have a lot to discuss. And I will finish with the uncertainty and the complexity surrounding this regulation, and maybe trying to find some solutions and some discussion to practical lawyers and companies. So,
Hi,
first
Tariq.
of all, yes.
Sorry for interrupting you. Your camera may be off. Yes, now it's working. Thank you. Sorry for interrupting you. You can go.
Okay.
Sorry.
Okay. It's okay?
I think you're back now. Yep.
Okay, good.
Let me know. You're on and off. Sometimes you go black. Now you're black, to my view.
Okay, good. So, first of all, a quick definitions, a quick terms. SCCs are, as you know, template data transfer agreement adopted by, for us, European Commission. They serve to provide appropriate safeguards when a destination country lacks an adequacy decision. SCCs are one of the primary safeguards explicitly recognized by GDPR, and by incorporating these clauses into a contract, companies create, in fact, legally binding obligations on both parties. Because of their flexibility, SCCs are probably the most popular tool for international data transfers under European Union law. And this is probably this flexibility which give us the opportunity to try to construct and build a safe framework again around the international transfer data. So there is a lot to speak about the definitions around the SCCs, what is an importer, what is an exporter, but I don't think it is the most accurate and important thing to discuss with you. Let's go immediately to the second point I want to discuss with you, the requirements SCCs must meet. What I want to share with you are two principal requirements I think we should pay attention. First, content requirements, and secondly, environmental requirements. I will pass quickly in content requirements, not because it's not important, but because it's maybe technical and case by case we could discuss about these content requirements, and the discussion will take place after. Maybe we will discuss about that, but the clause imposes a comprehensive range of data protection obligations to ensure European Union level protection. As you know, we have purpose limitation and lawful processing, security and technical measures, data subject rights or government access and transparency. All these kind of clauses of obligations include and SCCs are something we have to meet the requirements. Without this kind of requirements, the SCCs can be invalidated. But why I don't want to discuss a lot about this topic. It's because even if the requirements are met, it's the environmental requirements which are complicated to comply with. Here we encounter the fundamental challenge revealed by Schrems II, as you know, the Schrems II decision. SCCs are contractual by nature, so they cannot bind foreign governments or override national laws. It means that if local laws force the importer to breach SCC's premises, simply signing SCCs is insufficient. This creates to companies two critical obligations. The first one is the data exporter must verify before transferring data whether the destination's legal system can uphold the commitments in the SCCs. So it means that the exporter should know the law of the destination, which is a huge obligation, heavy obligation on companies who manage international transfer data. The second critical obligations the Schrems II impose is the supplementary measures when needed. When the legal environment poses risks, parties must implement additional safeguards. And these additional safeguards could take place with technical measures like encryption, as you know, or pseudonymization. It could also be contractual measures like additional clauses requiring immediate notification, or simply organizational measures like strict data access policy or dedicated privacy officers in the SCCs. All of that is not sufficient to comply with the GDPR. You know, as you know, the SCC are not sufficient if the environment, the legal local environment, can breach the SCC's content. So this creates some of uncertainty and complexity, and this is the third point I want to share with you. Let's take the Schrems case as a laboratory to do that. The invalidation of the safe harbor and the privacy shield by the European Court of Justice led to adopt the data privacy framework, which is not enough as an appropriate safeguard too. The Irish Data Protection Commission's action again, Meta, in May 2023 is a proof of that. So organizations now face the complex task to evaluating foreign legal systems because safe harbor, privacy shield, or data privacy framework, which is in force now for the last one, are not enough, as we know, in Europe to comply with the GDPR when you have the environment which is not which don't let the SCCs comply with the minimum level of protection according to the GDPR. It means that organizations now could ask some key questions, include how do we assess the law and practice of a destination country, what constitutes adequate judicial oversight, or also how do we evaluate the effectiveness of available remedies. These examples of questions led to practical questions, and the solution I think we could, and I'm speaking now as a lawyer, the solution we could find to help companies to comply with this kind of obligation is to work together with the head of information system, because the solution is more a combination with technical and legal help to companies, and not just a technical one or just a legal one. So this is what I wanted to share with you, and I will happy to answer questions after. Thank you very much again for your invitation.
Ale, you're still on mute.
Thank you. Thank you, Tariq. It is also our pleasure to welcome our other special guest, Fábio Calil. Fábio is a Brazilian attorney, graduated from Pontifícia Universidade Católica de São Paulo, and postgraduated in corporate law by Fundação Getúlio Vargas. With over 10 years of law firm experience, Fábio joined 3M Brazil in 2015 as a local legal counsel, supporting various business units and staff functions, with increasing responsibilities up to Latin America General Counsel for the Consumer Business Group. Since 2020, working with privacy as the LATAM SME and data protection officer where required. He currently leads all aspects of privacy and cybersecurity across Latin America and serves as a global privacy counsel to 3M's marketing organization. Fábio is also a member of the International Association of Privacy Professionals and holds certifications, CIPPE, CIPP US, CIPM, and CDPO BR. Fábio will present us some overview of 3M's governance vision and practical strategies for international data transfers. Thank you, Fábio.
Thank you. Can you guys put up the slides, please? As a good old corporate lawyer, I need slides to speak on. So first of all, thanks everyone for having me here. It's an honor and a privilege to be speaking on this important matter. And just that quick disclaimer that we usually say. So the views here are my own and not of the company. I'm not representing 3M on this. So it's just a little bit of my experience of how I have lived through these matters and trying to share a little bit of my view here with you guys. I hope that's helpful. So briefly, before we get into the data transfer rules, I'd just like to give a brief overview of 3M, provide some some facts and numbers of 3M, usually not known as a 3M brand, but many others. So we're over 120-year-old multinational company headquartered in the US, in Minnesota. with global presence, operations in over 50 countries around the world, which I think it's one of the reasons I've been invited to this event. With operations in all these countries, you could only expect we should be learning more about data transfers, cross-border data transfers, right? But before we dive into this, a few more numbers of 3M. 62, and those numbers I need to peek here because we had a spin-off of our healthcare business, now Solventum, last year. So all of the numbers that I took 10 years to memorize and get familiar with have changed. So I need to read some parts of it here. But over 62,000 employees, almost half in production roles, over 1,400 patents in 2024. So last year, over 135,000 patents overall, the company's history. The slide shows here 49 technology platforms, which 3M uses in our products. We commercialize those products through 3 business groups: safety and industrial, transportation and electronics, and consumer, which is probably the one that you know more brands on. So these are the brands here on the top of the slide. You're probably more familiar with Post-it Notes, Scotch, Scotch-Brite, Command, Blue Tape. So a few brands there that you may see on the markets. And fun fact for those of you who don't know, you're never, or you're likely never, more than 10 feet away, more than 2 meters away from 2 or 3 meters away from a 3M product or solution. As a matter of fact, if you're watching this from a computer or a smartphone, you probably have 3M solutions embedded in those devices, such as adhesives and optical films. $23 billion of sales in 2024. So that gives a magnitude of the size of the company and the complexity of the operation. We can please move to the next slide, where we'll start taking a quick look at the global data transfer regulation landscape. Let me see if I can move it. Yep, I got it. So I borrowed this from IAPP. It's already outdated, even though I picked it from the website from IAPP in March. And it's outdated because of the new US DOJ bulk sensitive data transfer rule. So, but I borrowed this to show how this is really global, how the landscape goes across the globe. And although already complex, especially taking into account existing requirements, first coming from the EU, of course, but all the Latin America printed out here, and few countries in Asia, led definitely by China, and now the US bringing complexity to that. But this complexity will only increase. You can see a lot of potential in the shaded areas of this slide. So that's what we are trying to anticipate as well. And of course, being from Brazil and with my role of DPO of 3M Brazil, I can't remiss to reinforce the importance of the new Brazilian SCCs, the Resolution 19, as Caio called out in the beginning, which will come into force in a couple of months now in August, but also relevant other countries in Latin America. So Mexico, there's a new update to the Mexico privacy law, many other countries in LATAM with data transfer rules such as Argentina, Chile, Colombia. So a lot of complexity. And of course, where it all started, the EU, and where it all still comes a lot of our light in this matter, it comes from Europe and European decisions. So we have a lot to learn on that. And let me briefly go into another slide borrowed from the IAPP into the US landscape. I won't dive very deep, I promise, but I think everyone is familiar now that the US has no comprehensive federal privacy law, but the states are quite active. And the slide shows that 19 states now, and I'm speaking, it's important to say June 11 at 8:25 my time, 10:25 Sao Paulo time. As of this exact time, there are 19 laws. In 5 minutes, this scenario may change, or it may have changed in the last hour or so. And there are two main branches of types of laws in the U.S. So there is the California. The California, I would say it's an outlier, and the Washington Privacy Act. And a lot of states follow the Washington Privacy Act, which was enacted in 2019. So a lot of states in that model, but also a lot of regulatory activity from California impacting the whole country and the whole globe, as a matter of fact. So many of you may have already heard from CCPA, California Consumer Privacy Act, the CPRA, which amended that law, and all of the requirements created by California. California is now the only state with a privacy protection agency of its own. Other states do have regulators, but not necessarily a privacy protection agency. Anyway, it's a fun role to try to navigate through all of the state requirements as we are trying to run the global business as well. And finally, back to the US, the Department of Justice bulk sensitive data transfer rule. I won't dive into many details here, but US companies are walking, and some international companies with operations in the US are working around the clock to get this implemented. The rule is already in force, and it does provide additional restrictions to data transfers to countries of concern, as called by the DOJ rule. Some of those are like well known: Cuba, Venezuela, North Korea, Russia, China. I'm missing a few others. There's 7. But more importantly, the obligation of US companies to ensure its vendors are following the rule. So that's where it gets tricky, because when they're talking about the global company operation, it is complex, but we kind of need to know where we are. When it doubles down to vendors, then it starts to get trickier. So it's a lot of work going on right now. But due to time constraint, let me not waste too much time here, and let me move to the next slide, which I think is what you were expecting more of me here today, because it's like about how to do it. And let me talk a little bit more. And it's a very simple slide, so I will apologize in advance. This was not borrowed from anyone as my product. That's why it looks so primary like that. But anyway, important to say here is that what you can do the best thing you can do in your organization or practice is to have a good data mapping. In my view, it all starts with data mapping. So know your data, what you process, where the data is, who has access to it within and outside, who are you sharing with, what's the life cycle of data all the way from collection to deletion. So it's important to know all that. If you need to keep one thing that I say today, is these 2 words: data mapping. This will be the key to most of your problems regarding privacy and data protection, of course. And if you know your data mapping, if you know where your data is, what data you have, you can build a good privacy program, honestly, not only the data transfer part, all of it, but definitely you will help your business grow. So in a sustainable manner, in a safe manner. You will actually provide tools to your business and to your business structures on how to even grow more their business. Once you know these elements, then it kicks in the how you do it. And the how you do it is, it will really depend on the type of your organization, of course, your business model. You must have something you can work with from a business perspective, ensuring compliance, of course, and then you act. and I divide it here in a very simplistic way. Apologize for that, but it's the way I see it. It doesn't happen as simple as this, but just a general guideline. So first, understanding your external and internal data flows, as you can see here in the two boxes right below data mapping. So on the transfers, you have where you share data outside of your organization, your clients, your suppliers, where you need to implement proper measures, including, but definitely not limited to contracts. We all know that we need to have legal requirements, legal language in the contracts. But honestly, from my point of view, that's the easiest part, mainly because we are given those by the data protection authorities or by the regulators or by the laws of each region or country. The contractual challenge is how we structure in a way that you ensure compliance while enabling business. So you need to be truly a business partner. You can't just throw up a lot of legislation, a lot of contractual clauses, and print it in a contract and build like 45-page exhibits, as we are seeing now. And I can tell you, those are not fun to negotiate with the business. Those are the biggest or the first to cross out to say, no, we're not accepting that. And that creates a lot of attrition within the company and with our external business partners as well. And as a corporate counsel, I would say a smart move is to call your attention on wins and not call your attention on contract negotiation. So when you bring a 45 or 50-page document to the table to negotiate, you're already in not the best position. So the biggest challenge for me, in my point of view, is to ensure the company, the clients, and the suppliers are complying with those, whatever we put on the contract, right? That meaning you need to have like proper notices, consents in place, manage them appropriately. You ensure you are appropriately addressing data subject access requests, the famous DSRs. You ensure you are addressing liability where applicable. You have a robust third-party risk management process, and so on and so forth. I could go the whole day here. But the key also is how to do all that in an efficient manner. And I'm going to go back to the top of the slide and mention the two words, data mapping. So if you don't have that one, you can spend infinite money, which we know we don't have in the corporate world, maybe in law firms, but not in the corporate world. You can spend all the money you have in fancy tools, AI, whatnot, you tell me. But if you don't know what you are managing, you will never be able to deliver a robust privacy program and ensure a compliant business operation, successful operation, right? So can't emphasize these two words enough. Data mapping, I think, is the key for everything. Again, not only for data transfers, but for the whole privacy program in any organization that you're working at. And at last, in the multinational context, it's also important to look internally. Also critical to have that in your data mapping. So to cover all intra-company, what we call intra-company data transfers. There are a lot of intercompany data transfers. So when sometimes we take these for granted, but when you're sending emails across the board, when you're seeing performance reviews of your employees, when you're talking, scheduling meetings, sending material, collecting material, photos, everything. It's a very complex net of data. So it's important to work closely with your IT organization, other support functions like key as HR, for example, for a company that has employees like 3M all across the globe, and ensure you have efficient data processing, right? Complying with security standards, not only privacy, of course. And my tip here to everyone listening, if it's worth, you can't really require all of this from your suppliers if you don't do it right. So it's kind of like you need to get your stuff together right first, and then you go to your suppliers. Of course, there are big suppliers that we can learn a lot from, especially the big tech companies that we most of times hire for internal purposes, like cloud providers, just to give one example. So we can learn a lot from them, don't get me wrong, but you need to understand how your organization works. They will provide the solution that is more interesting for them. We, from internal perspective, we need to know what data we're processing and how and where and so on and so forth. So with that, I'll turn it back to you, Ale, and I'm available for questions or discussion. And thank you. Thanks again for the opportunity.
Thank you. We will now ask our speakers a few questions. Fabio and Tariq, please feel free to respond as you wish. So Brazil's Resolution 19 from the Brazilian DPA, which regulates the international data transfers in Brazil, adopts language requiring controllers to demonstrate the effectiveness of safeguards, but does not provide any official template or checklist for the risk assessment. Meanwhile, as Professor Tariq mentioned, SRAMS 2 requires the demonstration of safeguards effectiveness, and the EU requires transfer impact assessments. So given this scenario, what practical approach would you both recommend to Brazilian companies performing these assessments? And is it possible to harmonize one due diligence process that satisfies both Brazilian and European standards without duplicating efforts?
I think, thank you for the question. It's a very good and interesting question, because it let appear probably the most difficult thing companies here in Europe have to encounter. It is knowing the local importer level of safeguards. Your question, the answer to your question depends a lot if you are in the point of view of the exporter or of the importer. And if Brazil, if I will take place from Europe, from European company, what is important is the local legislation of importer, because we have to be sure that, as I mentioned in my presentation, the environment, the legal local environment will provide a sufficient level of protection. What is sufficient level for us is the GDPR requirement. So that is the most important point after answering the question of the point, if I speak of the point of view of the importer of the or of the exporter. And for the question to know if is it possible to harmonize, probably with working together. And that's why thank you again for this webinar, for this conference, because this kind of connection let us, and I'm talking now as a lawyer, make connection and deeply know the local law foreigner now for Brazil and US, and that's what we can after explain to our clients that the local environment could be like that or not. So is it possible by creating an international network connection and working on both comparison with now for you Brazilian legislation and European Union legislation, including US, but US in fact it's the most important problem I want to say for European Union, because the most important transfers are with US. So that's my answer.
Yeah,
Thank you.
Thanks, Professor. I just to complement, to add up on that, I agree. And I think it really depends on the operation that you're running. If you're running an operation in Brazil only, like a small shop in Brazil, and you don't use any kind of software, you're running a pen and paper kind of business. It's one scenario. If you think you don't have international operations, but then you use Microsoft Office in your computers, then you may have a different perspective, and it gets complex as the business model grows and and increases complexity. So, speaking from a multinational company, and of course, each company is one company, so I don't want to put everyone in the same bucket here, but there's a lot of tools, there's a lot of resources in the multinational world, even though they are limited, but there are a lot. There's a complex IT organization to help enable all that. So it's kind of easy to say, but it's easier said than done, right? But it's to your question on the transfer impact assessments and the lack of requirements. The Brazilian authority is new, is learning, and they, from my experience, they seem to be very open to foreign approaches. To let's look at what Europe is doing. Let's talk with other regulators. We know that the frontiers are much closer now with technology and the world as the world is evolving. So my take on that is, yes, even though it's not clearly stated in Resolution 19, companies should have some sort of transfer impact assessment. Does it need to be an out of the box, like a $100,000 solution? No, it's just a document that shows, because when I always talk about this internally, any other matters, not data related, but when you put things in writing, you think of it. You go back and say, is this what really is happening? And then you go check with whoever is doing those transfers, whoever is using that vendor. So the sole fact that and you can do that in an Excel spreadsheet, you can do that in a Word document, you can do that in a pen and paper, but the sole fact that you draw a data flow, and I go back to my data mapping emphasis, shows you what is happening and how data is flowing and what concerns you should have in each point of the discussion. And I think that is ultimately what a transfer impact assessment is. A pretty name, so companies can charge a lot for it. So it can be a product, but more importantly than following what is written in the regulation is for companies to understand their data flows and ensure they are putting proper privacy and security measures along their process. And of course, it will always be, to the point where you asked about harmonization, it will always be to a multinational company, and I think to any relevant sized business, a risk-based approach. You can't do it all. And what I feel from authorities, from our interaction with authorities, data protection authorities around the world, is they are not looking for a beautiful checkbox structure. They're looking for, what have you done? And when you show it to them, this is how I look at my process, you will always know about your process more than any authority. So you're the one explaining. We are the one educating the authorities to say, this is how it works. And authorities may have pushbacks and may say, no, that's not the way it should be because the law says this, this, and that. And then you can say, okay, well, but there will be no service because of this, this, and that. So it's all about a risk-based approach from my perspective, and designing and talking with authorities to say, this is what I have. This is how I look at my process. And that cannot be 35 PIA different models. that needs to be a single model to be effective. That's my take.
You have a point, Fabio. Thank you, and also Tahik. And only to add some perspective from here in Brazil, you mentioned something really important, Fabio, that is the data mapping. And companies in Brazil, obviously, most of them, mainly the major companies and the medium ones, they did mapping. But when they did that, probably they didn't map international data transfers because it was not yet regulated by the Brazilian Data Protection Authority at the time that they did the data mapping. So what companies are doing now is to map international data transfers, and they have a truly a challenge to map it perfectly because, like you said, Fabio, there are international systems. They have big techs. They share data with companies that store its data, for example. So they even don't know where data is and to where and if data is being transferred internationally. And because of that, companies are in Brazil asking us, so I need to amend all the contracts I have with vendors because since I don't know, since I'll not be able to map it perfectly until August 23rd, when SCCs Brazil will enter into effect. So we need to amend all the contracts. And to you, Tahik, Professor Tahik, and to you, Fabio, what do you recommend for companies? Do companies need to amend all their contracts, or you can address that in a more efficient way?
If I can start, I agree totally with what Fabio just said. It's not just only international data transfers. In fact, in Europe, we have a difference between transmission of data transmission and data transfer. Data transfer for international transfer, data transmission for any kind of movement, data movement. So in reality, the data mapping Fabio is talking about is a general recommendation, and if it take place in an international transfer, okay, so the rules will be specific, but in reality, this mapping is the center of everything. And to answer your question, we can here see not a lot with the huge company and multinational, but we can see that this is a lot about law is externality for huge company. It's an externality, and there is a benefits risk balance to see if they need to review all their draft contract, of if they want to take the risk to go to the authority, administrative authority or judicial, and they will see what the authority. There is this kind of economic approach and in balance risk and benefits. So it depends case by case. It depends of the company. Some company should comply as soon as possible because the benefits are more important than risk. For other companies, if they have to change all their process, as Fabio said, it's our process, we can't change it. Change the process means change the company. So they have to manage differently. So an audit of the company is probably the first step to deal with this kind of problem. And if I can mention something else, I don't have the reference, but I can share that with you if you want. A recent study showed that the company who comply with GDPR here in Europe are more secure about cybersecurity, and what appear in the beginning as a burden, comply with GDPR, is in fact in the end something valuable to clients because they can show that they are very secure about the data protection. So this should enter in the balance of benefits and risk. And I don't have a specific answer, but it case by case, and it is the lawyer job we have to do. And everything start, I totally agree with that, with a good data mapping.
Yeah, I agree, and I think the best response to your question, Caio, is, as Professor Tariq just said, I fully agree. It really depends. Depends on the business, depends on your appetite to risk. It depends on how you drafted your contracts to begin with. I mean, there are many operations that are not relying on a contract. So especially in Brazil, where we don't need a contract. So you hire, you buy an off-the-shelf software and you start using it, and you don't realize until you do either a data mapping or you start with a data transfer impact assessment because you think that will solve all your problems. And then you start realizing that, oh, so we accepted all of these terms. The answer really depends and varies very much in a horizon there of what the company has done so far, how every change to a template in a corporation like 3M requires a lot of effort, a lot of alignment, even if it's like taking a 16-page SCCs that is required by law. So I'm not saying that I want to change the business contract. It's required by law. That requires a lot of effort internally to change a contract. So our challenge as internal in-house counsel is to come up with contract types and contract languages that will facilitate this implementation without changing contracts every now and then. Because if we need to change a contract every time a template, every time a new requirement comes up, we can just close the shop. And because we'll work only for that. And we want to be mindful, especially with artificial intelligence kicking in and helping us enable our work. We need to be mindful that our time is limited, and we need to focus the in-house counsel time in more strategic places. So instead of wasting a lot of time negotiating changes to a contract, and I'm talking about internally, I don't even went internally yet. It's when you go externally, it all changes. But I'm talking about talking with IT, talking with procurement, talking with the business, and creating all of those internal engines. So it will really depend. And I think I view my job as a intellectual job to create a contract language that won't need to be amended every year, or that will need to be amended at least once a year, and not more than that. So that's the internal challenge as I see it. But I agree with everything that Professor Tariq just said too.
Thank you very much, Fabio and Professor Tariq. We've prepared one last topic, and in this time that we have left, I think you could bring us your approach and, of course, your final considerations. No need to rush, but so I believe this next topic, it really speaks to everything that you have brought up until here. I think we are all very much aligned on this, but it's sort of a more critical and more specific question regarding the SCCs, which is a provision, like there's one specific provision under Resolution 19, which is coming into force within 2 months. So there was a 12-month deadline, and now it's approaching. So companies are really looking forward to know regarding those SCCs. The Brazilian Data Protection Authority, the ANPD or ANPD, it requires that the standard contractual clauses be used in full and without modification. And in those next 2 months, this will come into force. So there are two main topics within this subject that we would like to hear from. First of them is many of the companies, they already use either the European framework or for SCCs or the big tech company contractual clauses as their templates. And do you think it is possible to reconcile those different clauses without creating conflicting obligations or legal inconsistencies? And I believe we have kind of already answered that, but I would like to hear from you. And the second one is, within this 2 months adaptation that is left, many of the companies have had to review dozens or even hundreds of contracts. And the big question is, where do we start? So how do we prioritize which contracts to update first? Should they prioritize data volume, legal risk, or commercial relevance of the partner? Which should be the criteria for this? And the first topic, how to reconcile the different clauses.
If I can start, the first question, I will be very short, because it depends on the SCCs and on the comparison. What I can say about European SCCs, we can modify the European SCCs if it's to improve the data protection. So there is some flexibility with the European Union SCCs. In reality, if you look the European Union regulation, everything is flexible. With one limit, the protection should be at least in the European standard protection. For the second question, more practical and maybe more useful for companies and lawyers, as I said, law is externality for companies. It's not for us. It's something which tackle all our day, but for them not. It's just something to manage, and it's not the most important thing. So economic consideration should be for companies the most important thing, and it means kind of analyze of legal risk. With something important to not forget, it's the ethical image, particularly for a huge company, for international company. So there is no general answer for that, but the economic consideration is certain, of course, the first thing companies should prioritize in this short time to comply with this new regulation.
I agree completely with the second part of the question. I think every company is different. They will have a different risk appetite. So we'll need to really understand what's more painful and address that first. To the first part, maybe I'll add a little bit of risk to the discussion and say that it's very hard in a global multinational environment, especially where when your biggest risks are with your vendors, and your vendors are big tech companies, to come with your form and say, hey, Microsoft, here is my form, you take it. Hey, Oracle, you take it. It doesn't work like that. So I think we need to understand and even learn from some of them what they are doing. And what I've seen more is like it's come with many data protection, data transfer regulations coming into force, including the Brazilian one. Our privacy and security exhibits to the contract, and I'm speaking to the master service agreements, master supply agreements. Those are becoming, the exhibit only, they are becoming like 45, 50, 60 pages long. In an era where we're signing documents electronically, does it make sense to print something that is given by the authority? Or can we take, I know the resolution says and the authority guidance says we need to implement in full, but what does that mean, like for a lawyer? If I incorporate those language by reference, if I reference the website where it's published, am I not implementing in full? I am, but is that risky? Yes, definitely. That's our business, right? We're all in the business of risk. So you just need to pick what risks you want to run. And back to one of the points that I said, it's less about the contract, in my understanding, and more about what you do with your contract. So you may be able to challenge a contract in court, but it's much more effective to show your process and say, I was concerned about this risk and I did this to address. Was it perfect? It will never be. All of the big multi-billion-dollar companies are not getting it right. They're getting fined left and right. So why do we think we're going to be perfect? We're not. But if we can tell our story and implement safety measures in our process in what we understood, my take is authorities around the world would be welcoming to say, okay, but it's not exactly what I was looking for, adjust this, but that would avoid a $1 billion fine. So that's my take. Get your process right, and you will be in a better position to talk if you need to.
And
Perfect.
if I can add just
Sure.
one word, please. Sorry, there is a proportionality principle in the European Union regulation, and it's totally what you are talking about, Fabio. Regulators and judges can't ask to any companies to do impossible things. So they analyze the reality and they confront this reality to the SCCs, and they adapt, of course, what they want according to this reality. So it's very important to understand that in reality there is some flexibility, even if you mentioned that the Brazilian SCCs cannot be modified. Sorry, I don't really know well the Brazilian law, but in fact, everything is flexible according to this proportionality rule here in Europe.
Yes, great. Thank you very much, Tahik and Fabio, Mateus, and Alexandra. Before close, I'd like to thank you all who joined us today. Your participation and engagement made discussion richer and more meaningful. Thank you, Tahik, Fabio, Mateus, and Ale again. And also, I think that we added something to people in Brazil with your experience in Europe and in the United States. So the idea here is to make it easier for companies in Brazil to comply with the Resolution 19. It's not easy specifically, but I think that companies had 12 months, and it's becoming the deadline is really near to its end. And what we've been listening, hearing from companies in Brazil is that probably they will ask for the Brazilian Data Protection Authority to postpone the data. So we haven't heard something specifically about that yet, but let's try and wait. If anyone, in one point only, if we are willing for Data Protection Authority to postpone the data, companies need to ask the authority to do that. So if companies are not yet prepared, so it's time for companies to go to the Brazilian Data Protection Authority and ask for the authority to make it to the next year or give more 6 months or so. So until now, 23rd August is the time for companies to be compliant with the Resolution 19, and we're going to wait for the next chapters. Thank you again. Thank you all, and see you soon in another webinar. Thank you, guys.
Thank you very much. Bye-bye.
Thank you all.
Thank you. Bye-bye.